figures. So there are a lot of figures which you can see. So I mean, there are drawings which are there. So these drawings are generally used to describe, very specific, all details, even, to the hardware level and to the software level of these details related to the functionality of the case. So this is an example of a utility patent. Then for every patent, once you file a patent application, it gets published. And once it gets published, you get a publication number. So there are different unique numbers which are associated to a patent. So what you see on the screen at the top, this is the granted patent number. It is a unique number which basically recognizes this patent. If you see over here, there are the names of the inventors who have filed this patent application. But there is an assignee, which is Apple. So assignee actually means the owner of that patent. So probably these inventors would have been working in Apple, and they would have developed this idea, but the patent is filed by Apple, and all the rights of this patent are actually assigned to Apple. Then there are different basically terms which are more related to patents, which is like it gets granted, it gets published, which I will talk about now. If you see on my screen now, this is an example of a design patent. So this is a patent again filed by Apple for a design or an ornamental look of the very famous iPod, the music player devices which a lot of us would have used. This is a design patent on iPod. Similarly, this is a design patent on another version of the iPod, which later on came. So think about in terms of that as soon as they plan to launch a new version of their product, they are also filing a design for a utility patents on that concept. Again, I'll show you some more examples. Just a second.
So what all do you describe in the design patent?
So in design patents, generally it is about how the design is looking and or appearing. So if you see, this is a design patent on the iMac, the desktop which Apple is selling. So it is the look and appearance of that design which they have prepared for a product. Many a times the product is sold because of its unique design and not because of its functionality. So design patent is to protect those designs as such.
In the description or in the claim, is there text related to claim and description, etc.?
Yes. So in design, there is no description as such. The description of the design is the drawings itself. The claim of the design is what you see over here. So there are generally in design patents, you would see a drawing in two form. Some portion of that drawing would be solid lines, and some portion of that drawing would be dotted lines. So the solid line is the claim of that design patent. So if you see on the screen, in this first figure, this part is the solid line and the lower part is the dotted line. So they are claiming this screen as the first claim.
So there is no text in the application, in the
there is
design
no text.
patent.
Yes, there is no text as such in the design patent because design patent relates to ornamental design or look and appearance of something. Text is generally present in the utility patent, which I showed over here for Apple's AirPod case functionality. I'll show you another example of a utility patent. Yes. So this is a patent filed by Microsoft on their Xbox Kinect functionality. So if you are able to see the drawing, there is a person who is standing in front of an Xbox or a Kinect sort of a device. And this patent is a technique for estimating a pose of a body. So this patent talks about how the device works to basically identify the pose of a person and accordingly use it in a gaming application. So this would have a lot of description and technique, how they are doing it, how they are doing image processing, how they are playing with the pixels. So all of those details are described in this utility patent application. So these are a few examples which I just wanted to share for patent. Then how you can search for patent? You can search for patent on Google Patents. So basically it's a search engine which you can simply use to basically search for Google patents. So you can simply type Google patent search and you can then use a lot of terms for which you want to search on a patent. So for example, if you want to search on a patent related to a smartphone with a sort of a very thin bezel. So you can use those terminologies as keywords and then search it to basically look out for patents which are related to that. You can even search on patents on various patent databases like US. This is the patent database for US patent office. So you can use this patent database to search for patents. Then even Europe has its own patent database. So you can search this for searching for patents which are European patents. Now, having said all that, and there are a lot of terms which are related to that patents, and probably I can discuss it about more in the subsequent session when I would be talking about, prior arts and all those things. But this, I just wanted to give a basic idea about how a patent looks like and what are the types of patents generally. Having said that, a lot of patents which are there are not generally used. So there are a lot of useless patents which are being filed by people, and those patents are even granted. So here are some examples of that. So somebody filed a patent on a mustache guard. Now this is of no use, and this was actually granted by US Patent Office. It is even expired also now. 20 years time has crossed now. Somebody filed a patent for a method of swinging a swing. I mean, we have been using swings in parks for so long. Somebody filed a patent for a method of swinging a swing, and that patent was granted by the patent office. And I mean, this is for no use. So not all patents are valuable. This is something which I wanted to emphasize on. If you see this, somebody filed a patent and called it as a beer umbrella. So it is a case holder with an umbrella for holding a beer bottle, because he thought that when he takes it out from the refrigerator, it is not chilled. So to protect that from sunlight, he basically designed this umbrella and a case holder. Similarly, there is another patent which somebody has filed, which has a pillow with a umbrella which could be retracted to protect him from sun rays when he is sleeping. So I mean, a lot of patents are generally filed, and there are a lot of crazy patents. So you can search. I mean, and you can see a lot of crazy patents which are being filed and even granted by patent offices for different purposes. So that doesn't mean that we can file a patent for everything. So having said that, we have to critically analyze that what are the things for which we should actually file a patent application, and that is something which I will be discussing in subsequent slides. So this is a basic structure of how the patenting system looks like in India. So I mean, the Controller General of Patents and Trademark Office, this is under the Ministry of Commerce and Industry, and under which we have our patent office. There are 4 patent offices in India currently, in Kolkata, Delhi, Mumbai, Chennai. And then there is a trademark registry which is there. So basically someone can approach and file the patent applications in these offices. Now, this is a patenting system timeline in India. So think of a situation where you are a student or you are someone who has conceptualized or developed some idea, who starts to think that whether I should file a patent application or not. So what are the stages at which he would move ahead? That is something which I am trying to explain over here. So somebody thought of a problem which he should solve, and then he thought of a solution which could be there, which he can implement. And then he basically conceptualized that idea, and then he basically reduced it to practice, which means he developed some prototype of that solution. Now, reaching to that stage, he got some confidence that, okay, I can file a patent application on this idea. So he contacts somebody who is called as a patent agent. Patent agents are generally authorized to prepare a patent application, file a patent application in patent office, and then he files a patent application in India. So when he files a patent application in India, automatically after 18 months, that patent application gets published, which means anybody can see it on a Google patent. Anybody can, I mean, that patent is available for public review and visibility after 18 months. So the life of patent actually starts from the date on which you file the patent application and till 20 years. But you can exercise your rights against somebody from the date at which the patent is published. Meaning that if you file a patent application and it gets granted, then you can sue somebody for his use of your technology from the date after the date of getting it published. As an example, if I file a patent application in 2018, it gets published this year in 2020, then this year onwards, if somebody is making a product on my technology, then I can sue him. Condition that my patent should be granted. I cannot sue somebody for a patent which is not granted. So after the grant, I can sue somebody. Then the patent is published and then it is open for examination. So generally in patent office, there are patent examiners who examines your patent applications against a lot of things. They examines that whether your technology or whatever idea that you have for which you have filed a patent is new or not, whether it provides a technical advantage or not, whether it falls under the any of the statutory categories which are not patentable in India. And based on that, the patent office generally issues a report which is called as a patent examination report. And in that report, there are generally rejections, objections which the patent examiner may have related to your idea, and then you have to overcome those rejections and or do certain changes to the description of your patent application as in required by the examiner to get your patent granted, and then the patent is granted after that process. Now, sometimes the examiner also calls for a hearing, which means that after issuing his first report of rejection and receiving your response to it, he can call you up in the patent office, he can discuss your idea, and then he can put forth his view or opinion. And then based on that discussion, he would ask you to make certain changes to the description of the patent application. And then accordingly, you can make those modifications and then the patent gets granted. So these are certain basic things which are related to patent. In terms of the patenting system in India, we have patent office, which generally deals with, where we file the patent application, which grants the patent application. Sometimes, the patent examiner does not grant the patent application. He may issue a rejection to your patent application. So you get a chance to basically appeal against his decision. You can appeal that, I think that based on my understanding of the invention and technology, this should have been granted a patent. And you can reach out to Intellectual Property Appellate Board, which is a appellate board at a status higher than the patent office. And then you can file a request over there for an appeal. And then in certain situations, the examiner's decision may be overturned and it can be in your favor and you can get a patent grant. Then above that, we have High Court, which is like General High Court, which we have in India. So typically for any cases which are related to patent infringement, those cases are generally heard in High Court. So High Court pass a ruling on generally infringement related cases in India. And then we have Supreme Court for only for certain situations. Somebody can reach out to Supreme Court and fight for his case. Okay, now there are two routes for patent filing in India majorly and even across world. So one is under Paris Convention and one is under Patent Cooperation Treaty. So the Paris Convention route is something where you can first file a patent application in a convention country. Convention country is like India is a convention country, US is a convention country, Europe is considered as a convention country. So all those countries which are part of that Paris Convention are considered as convention country. So this is the first way of filing a patent application, where you can do a first filing in a convention country, and within 1 year of that you can file a patent in another country which is also a convention country. So for example, I can first file my patent in India, and I can within 1 year of that filing, I can file a subsequent patent in US or in Europe or in Australia or in China, any other country. Similarly, there is another way of filing a patent application, which is a PCT route, which means that you can file a patent in a WIPO, which is like World Intellectual Property Organization. It is called as a PCT application. So WIPO basically covers all the patent jurisdictions, you can say it in a way. So many countries are a designatory of WIPO. All major countries are basically designatory of WIPOs. So you can first file a WIPO application, which is a PCT application, and then you get 30 to 31 months of window. You can wait. I mean, many a times it happens that somebody is not very sure of that whether I have to file a patent application in all countries or not. In such situations, companies or universities generally follow this route where they first file a PCT application so that they can get a 30-31 month window. They can make a decision even after 28 months, and then they can file in any designated countries like US, India, Japan, or China. So these are two major routes by which patent filings are generally done in India or across organizations. So having described a basic idea of what a patent is, what are different types of patents, I would want to emphasize on certain things which are related to patenting. So patents are generally granted for something which is new and inventive. This is the first and most fundamental principle of deciding whether we should file a patent application or not. So when I say something is new, as I mentioned, whatever you were thinking of to file a patent application, think in terms of whether it would have been already disclosed in public domain, which means whether a research paper is already there or not on that aspect. So if I am thinking of an algorithm which I can use to improve the efficiency of how my smartphone works, and if I want to file a patent application on that, so I have to first see whether in existing literature that technology is already described or not. If it is there, then in no manner I can get a patent on it. So that is the first and foremost thing. It should be new. I mean, your idea should be new, not known to anyone, not known to public. And that's the reason many big companies, before even doing a marketing of their idea which they have conceived, which they want to offer it to a customer, they first do a patent filing, because otherwise they may not get a patent on it. So novelty or new is something which should be there associated to a product or a process or any functionality for which you want to file a patent application. The second thing is inventive step. Now this is a very, a little complex term. People get confused to it, when they talk about an inventive step. Inventive step is something which means something which is not obvious. So for example, just to give you an example, let's suppose I thought of an idea for filing a patent application, for providing an effective route for somebody to reach from one location to another location. Now I thought of improving the Google Map functionality. So I thought of making an application which is like a Google Map, but which can provide a route which is more effective than the route which is being provided by Google Map. Now the algorithm that Google Map is using basically considers a lot of factors. It considers traffic, it considers the shortest path. Now I thought of considering some more factors which can improve the route efficiency which is being provided to suggest a route. I may not get a grant on that patent. The reason being is it would be very easy for somebody to basically pull out the functionality of Google which is available, or pull out the algorithm of Google which is available, Google Maps which is available, and pull out another document or a research paper which talks about a route optimization algorithm which considers many other factors other than what Google Maps is considering. Now an examiner who is examining your patent filing application, he can basically see those two documents and say that it is pretty much obvious for somebody to include some additional factors for improving the route which you are suggesting. In such situations, he would not allow you a patent application. So your idea has to be new also, but it has to be inventive also. So continuing with the same example, if suppose I develop an application to provide a map, it's an application which provides a map or a route for somebody, and I say that this route is different than the route which is provided by Google Maps. So I would say that my algorithm is different. I am not using the algorithm which Google Map is using to suggest a most effective route to reach, let's suppose from my home to office. My algorithm basically considers a lot of added factors also, a lot of other factors also which can improve the route which I am suggesting. So yes, my idea is new. I mean, nobody thought of that. Even Google Maps was not considering that algorithm. First parameter is okay. I mean, the idea is new, so yes, I can think about a patent filing. But if I can prove to the patent office that the route that I am proposing is an effective route in terms of that it provides a technical advantage to the systems that I'm using, then yes, I can file a patent application. I should file a patent application for it. For example, if I can say that the route which is proposed by my app, which is very similar to Google Maps, is something where there are no slopes, there is no bumpy roads, it is less accident prone. It basically, when my vehicle moves along that route, then the fuel consumption that my vehicle has to undergo is very, very less than compared to the fuel consumption that I had to undergo when I was using the route which was provided by Google Maps. In such situations, if I'm able to prove that yes, I am basically providing an advancement in the technology to the existing systems, then yes, I can file a patent application. I should file a patent application for that. So this is the first and foremost thing which people should understand when they think about filing a patent application, that your idea should be new. In simple words, you can first do a basic Google search, or search on YouTube, or search on Google Scholar, or search on Google patents also, that whether something very similar is already existing or not. If something very similar or exactly same is existing, then the chances of getting a grant on your patent should be very low. Second thing is obviously inventive, which I mentioned that it should be technical. Your invention or idea should be technical in nature. It cannot be a non-technical idea, and it should provide some advantage to the existing state of the art. Now, the other thing which many of us should also consider is to differentiate between invention and innovation. A lot of people do innovation. That doesn't mean that it is an invention. When I based on my experience working in product companies, I have seen that there are a lot of engineers who would develop very effective solutions, who can develop solutions which improves their existing product line or existing techniques which are already there, but they are not able to get patents on a lot of such solutions. The reason being, we call it as innovation. It is not an invention. Invention is something which is legally defined by a patent act in India, and even patent acts which are available in other countries also. So as an example, you should first think whether your idea is an invention or whether it's an innovation. So now, what is an invention or what is not an invention? So the good thing in India is that unlike US, in India, we have a negative list. We have a list of what does not fall under a category of an invention. I'll just take a pause over here. Sanjay sir, I think we've crossed 1 hour. I mean, we have time. Can we extend it to 10-15 minutes if it is possible?
Yeah, sure. Please do.
Sure. Okay. So yes. So this is a negative list which anybody can easily see to understand for what all things he cannot file a patent. He should not file a patent application because this is by law not patentable. These are the categories which are non-patentable subject matter. First is an invention, primary or intended use of which is contrary to law or morality or public health. So for example, if you develop a device to do a theft, you cannot file a patent for it because it is contrary to the morality, it is contrary to the public health also. Similarly, you cannot develop a device and go for a patent filing which is for a gambling application. So that is an idea which is contrary to the law. Gambling is not allowed in India. So you cannot develop a thing and you can go ahead and file a patent application on this idea. Then the second category is a mere discovery of a scientific principle. So for example, if based on something which you were exploring, you discovered an existing scientific principle, then you cannot file a patent application for it. For example, if you implemented some integrated circuit and sort of proved the Kirchhoff law, you cannot go ahead and file a patent application for Kirchhoff law because it's an existing well-established scientific principle. So a discovery, for discoveries, you cannot file a patent application. It's a non-patentable subject matter. Again, something which is frivolous also, you cannot file a patent application for it. For example, if somebody developed a clock which has a dial pad in which each hour is divided into 100 minutes, you cannot file a patent application for that. An hour has 60 minutes. So that's a non-patentable idea. Then the mere discovery of a new property or a new use for a known substance, you cannot file a patent application for it. So for example, if you talk about if you talk about something which is like say hydrochloroquine. So we in this COVID situation, we have heard a lot about HCQ. Now HCQ was generally used as a immunity booster. Now somebody cannot file a patent application on saying that I'm using HCQ to treat COVID. Whether he is able to treat it or not, that's altogether a different story, but you cannot file a patent application for a new use for a known substance or a mere reuse of a known process. Again, you cannot file a patent application for mere rearrangement or arrangement or rearrangement or a duplication of a known device. So as an example, what I could suggest is that you cannot file a patent application where you can say that I have developed a bucket which has a torch in it, because I'm not able to see in my bathroom when the light is not there. So you cannot file a patent application for a bucket having a torch, because it is nothing but a mere rearrangement of two known devices, and it is even giving the predictable result that if I install a torch in a bucket, it would give me the predictable result. So that is another category for which you cannot file a patent application. For method of agriculture and horticulture, you cannot file a patent application because these are generally covered under Plant Protection Act in India. Anything which is related to atomic energy, you cannot file a patent application in India because it comes under Atomic Energy Act. So you cannot do a patent filing for that. And this is something which is more interesting for our, students like us who are generally there in engineering college. You cannot file a patent application for a mathematical formula. You cannot file a patent application for a business method. When I say business method, you cannot file a patent application for a banking transaction system unless you write the patent application in a way that it sounds more technical, it has some technical aspects related to it, and the claims are not claiming a business method. You cannot file a patent application. You can file, but it would not be granted. You cannot get a patent grant on a mathematical or a business method. Computer program per se. Now, this is something which is very much discussed in patent industry in India. It is because we have a lot of computer development programs and coding platforms which are available, software development platforms which are available. Coding something is not a big task now. You can automate a lot of things by writing a software code for it. So purely for software code, you cannot get a patent. So computer program per se is not patentable in India, but that doesn't mean you cannot get a patent on a software. If you have written a code for something, or if you have developed a prototype for something, it has to bring up something more than merely a code which automates something. So I'll discuss some examples where it could be proven that you can get a patent application for a software related invention which is more than merely a code. Then a mere scheme or rule of method of performing a mental act or a gaming, you cannot get a patent. So in India, it is very difficult to get a patent application on a gaming application. So, but that doesn't mean you cannot get a patent application on Kinect or Xbox. That is a hardware device. You can write a patent description where you can describe how you are capturing 3D images, where you can describe how you are actually doing image processing to actually estimate the pose or the appearance of a person. For that part, you can get a patent application, but for purely a gaming application, you cannot get a patent application in India. Presentation of information. So if you have seen, if you want to say that I am presenting information in a unique manner, for that you cannot get a patent application in India. Which could be like if you've seen that different Windows have their own way of presenting icons or tile structure. If you have seen on Nokia phones. So in India, it is difficult to get a patent application on mere representation of information. But in certain situations, you can get a patent on that, but you have to prove that it provides some sort of a technical advantage to it. So if, for an example, I can say if all of us who are using Android phones, there is a feature to basically group a lot of applications in one folder. So, on a user interface, we have a feature where we can club a lot of icons of patent applications, icons of a lot of mobile applications into one folder depending on its functionality. For that, I can file a patent application because it is providing me an ease of use. It is providing me, a short. I can use my phone for a lesser amount of time compared to what I would have traditionally used. So if I say those arguments, then I can probably file a patent application in India. For a topography of integrated circuits for electronic students, we cannot file a patent application in India. That's a non-patentable subject matter. Traditional knowledge. This is again something for which you cannot get a patent grant in India. So for example, if you say that I will file a patent application of using turmeric as a healer for an injury, you cannot get a patent application in India because that is that is known as a traditional knowledge in India since a long time. So in US, somebody filed a patent application for using turmeric as for healing an injury, but that patent was later revoked because somebody from India mentioned that this is there known in India since long. It's a traditional knowledge, so nobody can get a patent on it. So these are some of the negative list or categories of non-patentable subject matters. So as an innovator or as a thinker, we can think if our idea is falling into any of these categories, then probably it would be a difficult situation to get a grant of a patent application in India. Again, I think I discussed about novelty and inventive step to some details. In the probably the next session, I would be discussing more about these details, like what is a novelty, what is inventive step, how you can do a prior art search to quickly see whether you can actually file a patent application or think in terms of filing a patent application in India. Some other things which you should also consider in terms of filing a patent application in India is whether my idea is workable or not, and this is exclusively for India. So in India, inventor has to, after getting a patent grant, he has to also show the working of that patent, that whether he would have actually implemented that in in working or not, or he's able to implement it in working or not. So if my invention, if my innovation is something which is merely at an idea level and I don't know how to implement it, I don't know how to really make it into an implementation, probably it would be difficult to file a patent application for it. Mere ideas are not patentable. But yes, if you don't implement it actually as a prototype, but if you know that these are the steps which I would have to do probably to implement it, and if you can provide those details in a description of a patent application, then yes, you can file a patent. You should file a patent application of it. So having said that, I mean, one thing which everybody can consider for deciding whether they should think of a patent filing or not is whether they can enable that invention. When I say enable that invention, means whether they would be able to describe those, at least those level of details in a patent description, that if somebody in that field of work reads those level of details, if he would be able to develop a solution on that, then probably you can file a patent application on it. As an example, if Sanjay sir works, let's suppose, in field of image processing or graphics, computer graphics, he knows that technology. And if I as a student think of an idea where I can work towards some idea which is related to stitching of 2D images and creating a panoramic image out of it. I have not developed a complete source code, or I have not coded that whole solution into a prototype, but I know the algorithms which I would be using. I know the changes that I would be doing to that algorithm to implement that solution, and I am able to describe it in a patent description, so that if Sanjay sir reads that patent and he is actually able to develop that solution using his own knowledge, then in such situation I can file a patent application in India. So I only need enablement details which are sufficient enough to basically go ahead and do a patent filing in India, and there are chances that I can get a patent granted in that. Other aspects which I think students and even faculty members should consider in thinking about whether they should go and file a patent application in India or not is, does your idea relates to a disruptive technologies? I mean, if you are working on something which is altogether a disruptive technology, certainly you should go ahead and file a patent application over it, because the chances of somebody already being filing a patent application on that thing would be very low. The chances of some research papers or public literature available on those lines would be really low, and there is a high chance that you may get a patent grant on it. Like self-driving cars. I mean, if you are thinking on those lines, then I don't think that there would be a lot of content which would be available for self-driving cars. So if your idea is a disruptive technology altogether, think on filing a patent application on it. If your idea is merely an incremental idea, if you're developing something which is a route optimization algorithm or something which can improve the routing for routing app, that is something, I mean, I would not suggest somebody to invest a lot of cost in doing a patent filing, because there would be a lot of literature already available out which would lead chances of getting a grant success in your case really, really low. Again, the third point could be, if your idea is something which can attract startups, which can attract government projects, product companies, certainly go ahead and file a patent application for it. I've seen a lot of tie-ups which happen between universities and industries, just because of the fact that those universities are working on those lines which the industry likes, or for which the industry has some solutions or offering. So consider a company who works in a warehouse related domain. So if the university is working and providing some solutions which are related to warehouses, then obviously that company would be interested in doing a tie-up and engaging with the students and see if they can use part of their technology. And in such situations, universities even get funding from those companies and full support for filing a patent application on those ideas. So if your idea is something which can attract startups, which can attract government projects, product companies, certainly you can go ahead and think about filing a patent application on it. Then detectability is again something which I think is valuable. So if you think that your idea is very much related to a backend sort of a thing. So for example, if your idea is very much in terms of a machine learning algorithm which you are implementing, or sort of a neural network algorithm which you are implementing, which would be difficult for somebody to see in a product, which means that if somebody reads your patent and implements that whole algorithm or idea in this product, it would be difficult to detect whether he is actually using your technology or not. In such situations, patent filing is not generally favorable. Patent filing should be more for areas where you are working on something which could be seen, which could be detected in an end product, for which you don't have to do a tear down sort of an analysis or completely read a source code or do reverse engineering to understand if he's using the technology of your patent. In such situations, if the detectability of your idea is very high, then yes, you should think about filing a patent application on those lines. So these are some of the points I think which I wanted to focus on in terms of doing a self-evaluation of whether you should file a patent or not. Then there are experts, which are patent professionals like me, who can then provide you further assistance in terms of whether you should go ahead and file a patent application on those lines or not. But these are the certain points which somebody can use to do a self-evaluation or assessment of the filing a patent idea or not. Having said that, this is the agenda for the next session. And just wanted to give a brief overview of that. And I would be talking about, particularly for students, what is the career in IP? If they want to pursue a career in intellectual property, what all things they have to do in terms of the work, how is the work like, and what are the traits which should be there in somebody to actually go ahead and pursue a career in intellectual property. I would also be discussing some examples of failed attempts to get a patent grant. We all read about success stories of somebody getting a patent filed or granted, but there are very interesting examples of failed attempts of getting a patent grant. And this is more important because patent filing involves a lot of cost, a lot of efforts. Not even filing, preparation of patent application requires a good amount of cost. Filing a patent application requires a good amount of cost. It gets almost 5 to 6 years minimum to get a patent granted. In India, it is particularly, the average years is like 12 to 13 years after filing a patent application that you get an actual grant. So it should be a very subjective decision. It should be a very critically scrutinized decision before somebody should go ahead and file a patent application. But having said that, that doesn't mean that somebody should not file a patent application, because in universities and in organizations like where a lot of thinking happens, I have seen very creative ideas which are being discussed, and people had simply submitted a research paper on those ideas, and the moment you submit a research paper on an idea, you can never file a patent application on it because you have published it in public domain. So you can file it within 1 year of publishing it in public domain, but probably you can, the chances of getting a patent over it goes really, really low. So therefore, I think I would like to conclude over here. Just one more thing I wanted to show to people is, particularly to the students of the university, like if you are in any of these categories, you can think about having a career in IP. So in building a career in intellectual property requires reading a lot of patents. So on an average, I can tell you someone has to read about 5 to 10 patents and understand in full detail on a daily basis. So if you are not a technology reader, if you don't like reading research papers, if you don't like reading as such, don't think about pursuing a career in IP. If you like to read, then certainly. If you like to write, and then also you can think about developing a career in intellectual property. If you're good in analyzing and presenting data, then yes, this is a field which is for you. If you want to work in a job which requires strategic thinking, which requires business analysis, which requires research and analysis, then this is a field which you can look up, and this is the right time for students who are in their third year to think about pursuing a career in intellectual property. If you find interest in legal topics, then yes, this is something. The job is purely a techno-legal job. It is an amalgamation of technology and some level of legal concepts. It does not require a full legal knowledge. I mean, you develop a legal knowledge over a period of time, but it does not require a knowledge equivalent to a lawyer. It requires you to have a good technical knowledge and some interest towards legal topics. So yes, I think these are the things which should be there. And yes, I mean, for a student like me who was little resistant towards coding, I was a software engineer, but I always used to face challenges in developing a software code or a prototype. This is an area which you can at least think about in terms of developing your career in IT, because you still are very much, you know, reading and into technology, but you are not actually developing a code. But that doesn't mean you have to understand. Career in this intellectual property requires people to interact with engineers who are, you know, product architects in their field, who are fellows in their field, who are been developing some solutions since past 20-30 years. So you have to interact with those people, and those people are very busy. So you just get a very limited amount of time to understand the technology. So if you are not good in developing something, in coding something, but you are good in understanding the technology, then this is a field which you should look up for. So that's all. I think I think the time was little constrained, but we anyhow have 2 sessions. So I'll cover a lot of things which I was not able to cover in this session in the next session. The last things which I would want to say is that for students particularly, like, look around for technical problems which are available, which you can solve. And the moment you think of a solution, think of, you know, whether you can actually go ahead and think of filing a patent over it. And to tell you, like, patents are not for individuals. Even in a group, people can file a patent application. So there are patent applications who has even 40 inventors listed over it. So 40 inventors work together on an idea and they file a patent application on it. So even if you're working in a collaborative work environment, you can together file a patent application for it. So that's all, I think, for this session. Probably in the next session, we would have some more interesting things to discuss.
Thank you so much, Sparsh, for this informative session. It would really help us a lot. But before we wind up or we conclude, there are certain questions in a question and answer section. Anupam ji has been asking that from where we can get existing literature on patents.
Okay, so this is a very good question, I think, and a lot of us ask these questions. So as a person who is not very much into patenting field, the first and foremost touch point should be your Google patents. So just like you open Google Scholar, you can search in Google for Google patents, and you can basically perform searches for some, in a similar way that you search for something on a Google, you can do a similar way searching for patents on Google patents, and you can get a lot of patents over it. So I'll quickly show you an example so that it becomes a little easy. Just a second. So I have typed Google patent. Are you able to see the screen, Sonu?
Yes, yes.
Yes. So I have typed Google patent search, and I open this, and Google. This is the search engine for Google patents. Now, assuming that I want to search for a patent application on a, let's say, for example, self-driving car. So I'll type self-driving car, and then I can use this plus sign. This is nothing but a AND operator, and I can, you know, write about a particular thing which I'm trying to search in that self-driving car. So for example, if I'm searching for self-driving car along with an Internet of Things related application. So when I do a search on it, so the results that I'm getting, these are basically talking about, you know, autonomous vehicles, autonomous mode of bimodal vehicles. So it's a simple way to do a search for patents which are there in, you know, Google patents. Now Google patent has its advanced patent search tool also. I'll show you that. And these are freely available. So you can use these platforms to do a patent search. So this is how an advanced patent search tool of Google patent search looks like. So in this, basically, you can provide a lot of things. Just give me a second. Yes, this one. So let it load. Yes. So if you see on the screen, it provides you a lot of options, not even just to write keywords, but a lot of other things also to do a search. So for example, if I talk about, let's suppose pose estimation related patent, which is filed by Microsoft. So in assignee field over here, original assignee, I can write Microsoft. And when I would search over here, I would get the patents which are filed by Microsoft and which are related to pose estimation. So, and this altogether is a topic which would require almost an hour or so to effectively search and find out results. But just to give a small answer for this is a basic technique which somebody can use to search for existing patents. And when I talk about existing literature, you can even search for open literature like IEEE papers or Google Scholar. You can search on those also.
We have few other interesting questions. Can people copy patents from other countries? Is it authentic?
No, it is not authentic. So copying is never authentic. By inherently, it is never authentic. So if you copy somebody's patent and do some tweaking over it and think of filing a patent application in India, almost 50% chances are there that when you file that patent application in India and it is examined by the patent examiner, he would bring that patent to you in his examination report and he say that, see, this patent is already there in US. So, and that chances are very high because the tools which are used by patent examiners in patent office are far, far advanced than the tools which a normal person would use. The tools which we as patent professionals use have a far advanced searching facility and capability to identify documents which are already there, and people are experts in those fields. So like as an initial stage of my career, I was an expert in doing a patent searching. So my job was to find out if this idea is already existing or not. So somebody who is expert in that field, a patent examiner is way more expert than what patent professionals are sometimes. So he would do a job of 1 or 2 hours and he would be able to give you the same patent from which you would copy the content. So that's not a good idea.
How many views are required? Is this thing related something to this? No.
I think this question relates to design patents. When you are showing, I think Ravi asked this question at that time.
Okay.
Yes.
Okay. For design patents, you can have only one drawing also. You can have 100 drawings also. So that depends. Like, so for example, if I want to, so if I talk about Apple design patents, which I shared. So for the design of Apple's iPhone, they would have filed almost 20 to 30 patents, different patents, granted design patents on it, which claims the design from different perspectives. So, I mean, in one drawing, they would have just claimed, the front screen with a circle over it, which talks about the touch bar that is there on the Apple iPhone. In another drawing, they would claim the view or appearance of the speaker icon, which is over there. I mean, if you see the bottom part of your bezel of the phone, you have some dots of speaker. So they would claim that design. So there could be n number of drawings in a design, claiming it from different design perspectives. So if you see on my screen, this is the design pattern for iMac. I mean, the desktop version of the iMac, which Apple provides. So it has almost many figures. So see, first figure is basically the front view. Second figure is the back view. And then third figure is another, this type of a view. So there would be a difference between the first figure and third figure. So they would try to claim the design from different aspects. So if you see this fifth figure, it is the side view. So it all depends on like what is the unique part of your design and what all you want to claim. So they have even claimed the side view also. So if somebody is implementing a product which is a design for which the front design is not same as the design of the iMac, but the side view design is same as of this, he would be infringing on this design.
People file the patent but never execute as an application then?
Pardon, Sonal, can you just repeat the question?
People, there is one question from Dr. Sheetal. She has written that people file the patent but never execute as an application.
I'm not sure I understood this question.
Okay.
Execute as an application, does it means that they never implement it as a solution in a product, or they never use it?
Yeah, that's what I also believe, because you were also talking about there are certain patents which have never been utilized. I think he's talking about same things.
Yes. So yes, I mean, that is true. I mean, a lot of patents are being filed. So whenever you file a patent, it is called as a patent application. So the right term to address it is a patent application. When you say patent, it means a granted patent. So if somebody is saying that I have 10 patents and none of them is granted, he is not having any patent. So patent is only called a patent when it is a granted patent. Otherwise, it is called as a patent application or a patent pending. So yes, this happens many times that people file patent application and they don't use it. So yeah, this is a very common.
Yeah, there's one. There are questions, 2-3 questions which I'm combining and asking. Major, it is they are asking about what is the overall cost of filing a patent in India? Genuine agents for helping to file a patent in India, and should we think first to file a patent and then publish it?
Yes, so actually these are separate questions in totality. So the cost of filing a patent application, so it is just not the filing cost. I mean, preparing a patent application itself requires a cost, because if someone prepares a patent application which is bad in shape, which is not as per the legal requirements which are there in as per the patent laws, then the chances of getting a success over it is very less. So you need to get the patent prepared from an expert, which requires his professional fees, his cost. Purely if we talk about the patent filing cost and maintenance cost in Indian Patent Office, it would be something around 20,000 to 30,000 or maybe 40,000. But the whole professional fees which is associated with that cost is more. I mean, if you talk about somebody who would prepare a patent application, he may take 50,000 or even 1 lakh rupees to prepare a good patent application. So that depends. But yes, patent and there is a lot of content which is, I mean, the cost is variable. So when you do a Google search and seeing how much a cost is associated with filing a patent, you would see variable results. I mean, there is no fixed cost sort of a thing. The only thing which is fixed is the fee structure, which is provided by the patent office. So like if you and particularly for small entities who are not big organization, big companies, in Indian Patent Act, a lot of options are provided that you can file a patent at a very reduced cost. So as an example, if for filing a patent application by a large organization, you have to pay 5,000 rupees. For a small entity like an SME or a startup, it is almost like 2,000 rupees. It is very less. It is almost 1/4 or even less than that sometimes. I mean, the cost of filing and maintaining a patent application many a times goes around 1 to 2 lakhs rupees also. So it is just not about filing. Once you file a patent application, you also have to pay a fee for maintaining that patent application year on year basis till 20 years of that life. Which is also a fee which somebody has to pay, the owner has to pay. So yes, it requires a good cost. The second thing is regarding the the question regarding the publication. So as I told you, if your idea is published somewhere, if you published an idea, or if you even discussed your idea on a event where many companies were there or many universities organized an event, and you discussed your idea or a project on which you are working to the students of other universities, and they found your idea interesting and they have written a blog over it, then the idea is gone. You cannot file a patent application for it. So that is why it is very important that before you make your idea public, you should file a patent application on that idea. So you cannot publish something before filing a patent application on the idea. And once you file a patent application, it automatically gets published after 18 months of filing.
Okay. Any average percentage fixed for getting the patents granted every year in India, particularly?
Actually, this percentage varies depending on the technology. So, I mean, for computer science related inventions, the percentage is very less, because the standards are very strict. The inventions are also very much incremental, not something like which is very much sort of a disruptive, which is altogether a new thing which nobody thought of. So the percentage of getting a grant for a computer-related invention, purely computer-related invention, would be less. Even within one technology. So, for example, for a computer-related invention, if I talk about neural networks, if I talk about artificial intelligence, these are relatively newer technologies. So the percentage of getting a grant would be little higher compared to if I talk about NLP or speech recognition-related technology. So there must be already somewhere around 5,000 patents available on speech recognition technology. So this percentage varies depending on the technology, but on an average, a grant rate could be not more than, I think, 10% or 15% of the total funding.
Is there any software where one can check whether the work submitted has been patentable or not?
Yes, I think Google Patents is the software which you can use to check whether your idea is patentable. I mean, somebody is already.
As soon as they grant it, it comes under it is indexed by Google?
Not even granted. After 18 months of your filing, as I said, that it gets published in public domain after 18 months of your filing. So
18 months duration has to be there. Okay. And if it is actually, it may be granted before 18 months as well, or it's 18 months are compulsory?
No, it gets granted after publication only. But sometimes.
In both utility and design patents, both?
Yes, but I mean, sometimes, it is like that. It is mandatory. Sometimes it gets granted before even 18 months, but the moment it gets granted, it gets published. So I have myself drafted some applications which got a grant in 10 months after filing it. But the moment it gets granted, it gets published.
Okay. Let us take one last question. Can you tell something about Australia patents, or why patent attorney is suggesting to file for this country?
I have not worked much on Australian patents, but more or less the patenting systems is similar in Australia as it is in India. I know one thing, that in Australia you can even file a standard patent, which is a low category sort of a patent, which provides you lesser rights, which is the life of which is only 10 years. But I think majorly the patent filings are, that I have majorly worked on US, European, Indian patent filings, because generally big companies have markets in these countries. So they do a filing in Australia also, but generally those things are taken care by people or law firms who are there in Australia. Okay. So like basic patent is prepared for India or US by people. But the same patent is same documents and everything same is used and shipped to the law firm which is there in Australia, who can do a patent filing in Australia. But legally, law-wise, everything is more or less very much similar. The only thing is that the standards for getting a patent granted in US are relatively easier compared to the standards which are there in Europe. So in Europe and India mostly follows the standards of European Patent Office. So in India also it is little difficult to get a patent granted. In Europe also it is little difficult to get a patent granted compared to getting a patent grant in US.
Okay. Thank you so much, Sparsh, for this entire session. You have actually talked about entire life cycle of how to file the patent and many. Now I think everybody might start thinking, and everybody would wait for your next session, and we would have actually good amount of questions in the.
I would just say one thing, that it is a very vast field. I mean, and in one session it is little difficult, and it's a new field for people. So like if we talk about a technical topic, people are little aware of already what it is, but patents is something which many people are not aware of. So consider this session only as a basic session to get some idea of patent. I think probably next session people would get a lot of insights on some specific.
Before that, they will actually surf the contents at least see the whatever you have conveyed in this session. That would also help. Sanjay sir?
I just want to say thank you. Thanks a lot, Sparsh. It was a wonderful session. And I'm already looking for your next session, and I'm sure many more students should get interested in it and aspire to make a career as a pattern specialist, as a pattern searcher, or a pattern analyst, or a patent expert, or things like that. And we hope that this will, and maybe you can also in your next session share a list of such companies who are active in this area and offer such kind of jobs to freshers in the patent field, and that would make them more excited in this area. And so I just want to say thanks a lot.
Thank you, sir. Thank you so much. And I think thank you everybody for attending this session. I must say as an ending note that this is COVID time, so everybody please stay safe and take good care of your health.
Thank you so much. Thank you, Sanjay sir, for allowing us to host this session, for connecting us with Sparsh. I would like to thank each and everyone in the audience for listening us patiently, for putting good questions. There's few of participants are also viewing you on YouTube. Today we have hosted this session on YouTube, and I think you are the first one whose session has been hosted on YouTube. But till now we have been hosting on Facebook. So now we have inaugurated putting things live on YouTube from you. Thank you so much.
And one last thing is, for all the questions which people would be having, it would be good if you can pen down all your questions, share it to Sonal or Sanjay sir, and post it to me. I would like to address all those questions in the next session.
Wonderful.
Sure.
Thank you.
Thank you.
Thank you. Okay. Bye bye.